The pillows are fluff thanks to Miss Emily. The couch is wide enough, join the family. It's all love while we laugh at first criminalities. Hey, 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 welcome to the Sofa Squad. Sipping from the cup at hey, hey, hey. Come laugh with the Sofa Squad. Can't roll my damn eyes hard enough. Oh, please, the puppies need me. Oh, oh, please, my body is rejecting none of that fancy credential stuff. I'm just here for the cringe binge. Hey, 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 welcome to the Sofa Squad. Sipping from the cup and hey, hey, hey. Come laugh with the Sofa Squad. Can't roll my damn eyes hard enough. Oh please, the puppies need me. Oh please, my body is rejecting none of that fancy credentialed stuff. I'm just here for the cringe binge. Hey, 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 welcome to the Sofa Squad. Sipping from the cup that hey, hey, hey. Come laugh with the Sofa Squad. Can't roll my damn eyes hard enough.
Hey everybody, I was on the other screen and I couldn't find the button. I was just sitting here like this, like an idiot, just sitting here waiting. I was like, hey, where's the thing? Oh, thanks for dropping the ones, everybody. I appreciate it. So y'all can hear me clearly. I do appreciate it. Thank you, thank you, thank you. I hope everybody's doing well. Miss Emily, I hope you're doing well. Miss Indy Lauren, I saw that you're not feeling good. I hope that you're feeling better. Tux, thank you for all being here and holding the sofa down, keeping the cushions fluffed, so on and so forth. I do appreciate y'all. So before we get started, y'all, there is a jury that has been seated for the Lori Daybell trial. That was very, very, very fast. Okay, like shockingly. Hey John, hey Mad. I hope everybody's doing well. Hey Charlie, hey Crystal. Pardon me. Hey Ann. Hey Chris. Hey Huma. So yeah, it's been seated. Now I was literally just going over here and checking again over in Justin's thing. So it says we have a jury seated. That was 2 minutes ago. 2. Back in court for day 2. This is 5 hours ago. She's wearing a purple blouse under a black blazer. Judge says we have 52 jurors approved for follow-up. And then 5 minutes ago, Lori is speaking with her counsel, Pamela Hicks. Now she puts her headset back on. And then I'm just going to go through a few of these real quick. One juror from the box and the rest of the jurors are dismissed. We have a jury of 16. About a dozen jurors relatives who were convicted. About a dozen jurors have relatives who were convicted of crimes. One man has 2 brothers who are convicted of murder. It says that they won't impact them. And let's see what else. Judge has done questioning the pool. Jurors have declared hardships. Let's see. Interesting woman says he believes he worked with a juror at Popeyes. She says that wasn't me. So yeah, so let me get back to y'all now. Okay, see y'all over here. So the jury's been seated. April 7th, opening statements Monday. So this is going to be very, very, very interesting. So yeah, I mean, there we go, right? Word from the courthouse, if you will, Lori's just being Lori, and that's how she's gonna be. It is what it is. I'm gonna be very curious. You already know the opening statements, please, right? Just to see how it goes. Even if she were to get up there and how do you say it? Read some very benign opening statement. You know what I mean? Like just whatever. I'm very interested in her tone and her inflection and her manner of speaking and her presentation, all of that, right? Because I feel like you could literally give her, you know, a TV instruction booklet and it's going to be kind of like drama, right? Oh, thanks, Izzy, for being a member for 3 months. Oh, pardon me. So yeah, I think it's going to be completely interesting. And also on that is to see her reaction toward like, you know, the state, like we've already seen, where she's kind of, you know, going head to head and you know, however you say it. I'm very curious to see how that goes. So, you know, we'll see, and very quickly we will. So, thanks, Izzy. I appreciate it. So today we're going to be watching Tylee's interview. Now, what we'll do, because since they've seated the jury, so the main things that I wanted to see leading up to this is, I wanted to hear everybody's side of the story again, right? This is, you know, air quotes old news, if you will. This has been out for years at this point. It's been years since I've rewatched it though, and obviously since this is what we're going to trial for now, we want to kind of remind ourselves of it. So we're going to be watching Tylee's story tonight. Last night we listened to Alex. The night before we listened to Lori. Now, what we can also do is, and we'll just see how the rest of the week goes or whatever, and like what's going on in court, so on and so forth. Then what we'll do from there is we can either like listen to Julie Rowe or, you know, whatever ones y'all want to listen to, right? So we'll just kind of play it by ear and see how the rest of the week goes and whatnot. I was on the other thing, well, like what I've been kind of doing in the background today is going through that 3-hour, what do you call it, Stefan Stern's phone call. And I'm going to obviously do a video on it or whatever, but before we get started, so how do you say it? I had I've got it from the thing that I'm doing at prison, phone calls from prison, check their channel out. They're like, yeah, you can react to my stuff, whatever. So I had done it and I quit recording on my side of it to be able to, like, you know, pull the parts I want to talk about out. So I was like, are you serious? So I was like, you know what? I'm just going to have to redo it. And I'm just going to sit here and listen to a little bit before we get started. And oh my gosh. I mean, even if you've already heard it, then you already know. The first 30 minutes, even the first 30 minutes of it is insane, right? It's like, I don't even know. It is what it is. So that being said, so that'll be coming out or whatever. Yeah, so we'll just kind of play it by ear. I wasn't expecting them to have the jury so quickly. Sorry, that coffee is so good and so needed right now. Oh my gosh, it's been a long day. So what we're going to do is I'm going to put this up here. Let me get this. Where's the other screen? Boom, boom, boom. And again, remember, if you're new to this, whatever, Charles Fallow killed, ambushed. They bring everybody in for questioning, interviews, I call them, whatever you want to say. And this is Tylee's version of it. So here we go. Now, once they start talking, drop a 1 if you can hear it. And let me just find the screen. I'm going to fast forward. Nothing's going on at this point in time. Okay, hold on.
Hi. So you have to spell your name because we're all taking guesses on how to spell it. We're not sure.
Tylee.
Okay, I was right. And what's your last name?
Ryan, Ryan.
And your birthday? And then, do you have a phone?
Yeah.
What's your phone number? Okay. So I know this is going to kind of sound like kind of a silly question because it's super broad. But can you basically tell me what happened today? And you can start at whatever place makes sense for you to kind of start and explain. And I'll probably kind of ask you questions as we go a little bit.
Okay. So I woke up probably around like 7:50, I want to say, because I heard yelling from like right outside my door. I don't even know where, but I immediately like jumped up, and I have a baseball bat because when I was living at my uncle's by myself, I just wanted something to like feel safer, and I'm not old enough to get like pepper spray or anything, so I was like, okay, I'll get a baseball bat. So I have that.
So your bedroom, you said right outside your bedroom door, and I didn't go in the house, so I'm at a little bit of a disadvantage. So what is your bedroom door open to?
My bedroom door open, so the room that my uncle was staying in, the room that's kind of like the guest room, if my room's right here, that's right there.
Okay.
And then my little brother's room, and then kitchen's kind of back here, so it's like a little hallway, and then right here is kind of where everything happened.
Okay.
Like the big, you walk in and...
Like big great room, kind of living room?
Yeah, right now it just has mirrors up because my mom wanted a dance room.
Okay.
So, yeah.
Okay.
Kind of unconventional, but...
Hey, whatever makes you happy. It's your guys' house. So.
Right. So, yeah, I immediately just jumped up and I grabbed my baseball bat and I opened the door, and it was my stepdad, you know, outside the doorway, and then my uncle kind of in the doorway, and then I could hear my mom behind him. And he was just screaming at both of them, like, I don't even know what he was saying, because honestly I was just too, like wired, I guess. So I told him to take a few steps back. I was like, you're too close, you need to step back. And he was like, don't tell me what to do. And I just kind of just stood there, and then my uncle kind of moved out of the way, and then my mom kind of went past him and into, like, the big room.
Okay.
Where everything happened, and so I walked with them, and then
So they were more in the hallway.
Yeah, they were at, like, the end of the hallway,
Okay.
basically. And so my mom walked all the way around, and he kind of followed them, and I just kind of stood. My uncle was, like, right here, and then my stepdad right here, and then me and my mom were kind of right here. And I didn't do anything with the baseball bat. I kind of just held it there, and he was getting really close to my mom, so I kind of stuck it out, like, between them, and they were both just yelling, and he was like, if you hit me with that baseball bat, you're going to go to jail. And I just kind of stood there with the baseball bat, and I didn't really say anything.
When you said they were yelling, who was yelling?
It was mostly my stepdad.
Okay.
Well, he was really the only one, like, yelling.
Mm-hmm.
My mom was kind of, like, responding, but I honestly couldn't tell you what they were saying. It was kind of just, like, all jumbled up in my head. And so I just kind of stuck the baseball bat out there, and then he just grabbed it and tried to take it. So I held on to the end, and then eventually I fell, and he kind of took it into his hands like he was going to do something with it. And that's when...
So when you fell, he ended up with the bat?
Yeah.
Okay.
And so I fell to the ground, and then my uncle kind of, like, I saw him take a step back, so my uncle, I think, grabbed him and kind of took him back so he couldn't, like, do anything.
You saw your stepdad, like, take a step back?
Take a step back, because he was really close to begin with, and then and so my mom said to go with JJ, and so I ran out the door, and then I kind of just stood there with my little brother. He was in the front seat of the car, and so I just kind of opened the door and just stood there, and, like, he was trying to get out, and I was like, no, we have to stay. We have to stay in. And I was like, oh, like, I told him, like, do you want to go in the Jeep? And then he was like, no. And then I realized that my car was blocked in, so I couldn't anyways. I was like, okay, like, just stay here. And then eventually my mom came out, and then we left from there.
Okay.
Yeah.
Do you know what happened inside of the house? Has your mom kind of explained it all to you?
I just kind of asked her, like, because I heard a noise which I know what it was now, but it sounded like, because I knew that the baseball bat was in there, it sounded like someone like took it and hit it really hard against the floor.
Okay.
And so I was kind of like Al's okay, right? Because that's my uncle. So I just wanted to make sure that like my stepdad didn't do anything to my uncle and stuff. And so she was like, no, like Al's fine. Like we're just gonna take JJ to school. And I was like, okay. So I just got in the car and then we went to Burger King because my little brother wanted breakfast, which was chicken fries for no reason.
Okay. I do dinner for breakfast all the time.
Breakfast for dinner and dinner for breakfast.
So to kind of back up a little bit, so you had talked about your stepdad, when you put the bat out, your stepdad was coming towards your mom. Can you describe to me a little bit better kind of what was going on there? Like, is there a reason you put the bat up?
Yeah, he was walking towards my mom, and I just didn't want him to do anything, so I kind of just stuck out the bat. Like, my mom was right beside me, and he was right there, so it wasn't, like, between them.
Okay.
It was kind of just, like, I just stuck it out to be, like, keep your distance, kind of.
When you say you didn't want him to do anything, what did you think he was going to do?
Hit her.
Okay.
Yeah, it's, for the most part, been pretty, like, mundane, but there have been a few, like, violent times with him when I was really scared that he was going to hit me or hit my mom, like, just because everything was kind of crazy. Me and him have always kind of not gotten along, like, just since I was little. And so there have been a few times that we've gotten in fights and stuff.
Okay, I just want to pause it real quick. I'm like totally engulfed in this. Sorry, I'm being like quiet or whatever, but here's my thing. So when she's describing this, now remember, and I'm kind of asking this too, because even though we've watched the last 2 nights, my memory's kind of like, okay, what exactly did they say? But you hear how Tylee's talking about, I put the bat out and then he kind of grabbed it from me. You know what I'm saying? Where didn't somebody, whether it was lawyer Alex, make it like, pardon me, that she had hit them with it? And it doesn't sound like that here. Excuse me. Now would I expect her to say that? No. You know what I mean? Her version sounds more docile, if that makes sense. Anyways, keep going.
Stuff like that. And so so I'm just kind of always scared of that.
Yeah.
Yeah.
And then, so that happened, and he grabbed the bat from you. So kind of tell me that again real quick.
So I kind of stuck it out, and this is when he was like, if you hit me with that baseball bat, you're going to jail, and I didn't say anything because I'm like, okay. And so I'm holding it by, like, the end of the bat, like the place where you hold it, and so he kind of took it, and I kind of, like, lunged forward and kind of lost, like, my footing. And so my mom was like, just let go, and so, I kind of, like, slipped and I fell, kind of on, like, my side.
Okay.
Yeah, and then from that, my mom said to go to the car, so I just got up and ran out the door.
Okay, did you see, when you fell towards your side, did you see what he did with the bat?
No, I wasn't really looking in that direction because from where I fell, the door was kind of more in my line of vision because I fell looking this way and the door was like right there, so I didn't look back.
So he was at a different line of sight than what you were looking at.
Yeah.
Okay. And then at some point you saw him kind of take a step back, and from what you're saying, and tell me if I'm wrong or not, you didn't necessarily see your uncle pulling back, but it seems like that maybe.
It seems like he wouldn't have taken a step back on his own, so it's more of an assumption than anything. I didn't see him physically take him back.
And does that make sense based on where your uncle was at that time?
Yeah, he was behind him, because he wasn't on this side with me and my mom, so he was behind him.
Okay.
Because that's kind of just the order where everyone walked out.
And when that happened and then your mom told you to go, did you see what happened with your stepdad and uncle?
No.
Okay. And then once you went outside with your brother, you never came back inside?
Oh, I went to go get my mom's purse from inside so that we could have, like, her wallet and everything, but this was all happening like I said, like in the
Okay.
bigger room right here. And so I went through the garage door.
Mhm.
And so the garage door is right here. And then there's like a little hallway. And then this is kind of where everything is. And then this is my mom's room.
Okay.
So when I went in, I kind of like just tuned everything out, ran to my mom's closet, ran back. So I didn't see anything, I didn't hear anything.
When did you go back in and get her purse?
After my mom came out.
Okay. So after you heard that loud noise?
Yeah.
Okay. And when you heard the loud noise, was your mom outside or inside?
I'm trying to think. I think she was inside when it happened and the door opened like immediately after.
Okay. So very quickly after the door opened?
Yeah.
Okay.
So it wasn't like a long period of time because I remember not like thinking about it for that long, and if my mom hadn't come out immediately, I would have, been thinking about it for...
Okay, so help me out here, y'all, real quick. So she goes back in to get the purse. Is she saying that the gun shot goes off, the loud noise is what I'm associated with a gunshot, and then she goes back in to get the purse, but it sounds like the room is like kind of right in there, so she's not having to go back into the whole scenario of it? Because I guess the part that I'm sitting here like, now work with me on this. Unfortunately, we know what ended up happening to Tylee. So when I say what I'm about to say, it's like, well, Paul, look, do you think Lori really cared? Because I'm sitting here like, so all this is going on in the house, and Lori at this time is trying to sell that this was self-defense, yet you're sending your daughter back in to get the purse. You know what I mean? Like, it doesn't make sense. Now, obviously, we know, that Lori didn't care. You know what I'm saying? Like, she wasn't looking out for people's well-being and safety and all that kind of stuff. But this whole interaction here, now also listen to how hers sounds more in line with like the way a teenager would describe this. You know what I'm saying? Versus the two adults who are truly orchestrating it. I think that so here's the thing. I don't think that when this went down that Tylee was in on the situation the way that like Alex was. I think that they probably knew like, well, she's just going to be part of this is going to be almost like a surprise to her too. The instigation, you know what I'm saying? And I think that Tylee was the type, because you know how like Melanie said, and even Lori, but Melanie's like, oh yeah, she was like a teenager. You know what I mean? That's just the energy I get from her. Like, she was gonna stand up, she was gonna say something, so she heard something wrong going on, she was gonna come out and be like, what's going on? You know what I mean? And then if you have it predisposed, all the stuff that Lori was probably saying to her and others about, you already know what she was saying about Charles, right? So anyways, let me go get this.
A lot longer than
Okay.
I had.
So obviously I don't know like your mom and stepdad and uncle like you do. I don't. So can you tell me kind of where the three of them were at kind of emotionally and how they were behaving when all this was happening?
When all this was happening, or like before?
When all this was happening. So like when you came out of your room and he took the bat from you and...
Yeah, so my stepdad was like, he was like, I don't even know how to explain it. He honestly just looked like kind of a crazy person.
Okay.
Like screaming, and like his face was beet red. He just looked like really mad. I remember when he took the bat from me, I saw his face for like a split second, and I honestly like, it didn't even look like him. He just looked like pure like rage. Like he was just seeing red. So I haven't really seen him like all the way like that before. That's like the craziest I've ever seen him. And then my uncle was kind of calm, like not super calm. Obviously it was like a stressful situation, but he's like, I don't know, he was kind of just standing there in the doorway, kind of just being protective of my mom, but not.
So the key word here, my uncle was calm. I mean, obviously we have hindsight here. My uncle was calm. Charles was like the craziest I've ever seen him. Well, we already know what was leading up to this, right? Charles had been putting all the pieces together. So he already knows. So he goes into this ambush. Lori's antagonizing him, getting things going. Alex already knows he's going to kill him, right? So Alex is like, they've entered, you know, Charles is now locked in to the prey. You know what I'm saying? Like the target's on him. Alex is just going in for the kill. So yeah, he's probably going to have that kind of like psychotic, like, everything's good. We're getting ready to get what we want. Hey, Tori, I hope you're doing well. So that part's very interesting. Yeah, Marissa says, how did Alex get away with cold-blooded murder? I mean, honestly, it's question of the century, right? Question of the century. Okay, here we go. As soon as I find the play button. Okay.
He wasn't yelling or really saying anything.
Okay.
And my mom was just kind of, he was yelling, and my mom was kind of just like talking.
Melanie was totally jealous over Tylee.
So, yeah.
100%.
But you don't remember, if you do, like what your mom was saying at all, or what he was mad about?
No, not really. I'm sorry.
Okay. It's okay.
Honestly, like
we're talking about something that probably happened over 2 seconds of time.
Yeah,
so.
honestly, it feels like 2 seconds and 40 minutes at the same time.
Yeah.
So I don't remember what they were really saying. I just kind of heard yelling over everything.
Mm-hmm.
I don't know. I kind of just do that whenever things are like really loud. I kind of just like tune what people are saying out, because I don't know, just yelling isn't fun, obviously, for a kid to hear. And with my biological dad, I always heard him like screaming and stuff, so I kind of just learned how to like tune it out.
So when you woke up to yelling, and you had said you weren't sure what they were actually saying, did you know who was yelling when you heard the yelling?
Yeah, I knew it was my stepdad. Well, at first I kind of didn't. Like when you first wake up, you're kind of disoriented. And then I remembered that my stepdad was like coming in to take my little brother to school today, so I immediately like knew it was him. Mm-hmm. And then my uncle I knew was staying, so I knew that was him. And then my mom, obviously, I knew that was her.
Mm-hmm.
Yeah.
And then, so you stepped out of your room and you took the bat with you. Is there a reason why you took the bat with you?
Honestly, I think that was kind of just like first instinct. Mm-hmm. Like obviously I didn't ever hit him with the bat or anything like that. It was kind of just for like security, I guess, to know that I had it. I didn't do anything with it. In hindsight, I probably just shouldn't have brought it out at all because it caused more trouble. But it was kind of just first instinct, and it was right by my bed. Uh-huh. So I kind of just like jumped up and grabbed it. So I'm trying not to put like words in your mouth and stuff. You're good.
So was there something in particular that you were concerned about that you would have taken the bat with you?
Only if he had been violent towards like me or my mom.
I'm assuming you're talking about your stepdad?
Yeah.
Okay. All right.
Yeah. But it wasn't like, oh, I'm going to take the bat and like do something with it. It was kind of just like, I need something in my hands to like feel safer.
Okay.
Do we think, or do we know that either Lori or Alex yelled to her to bring the bat? Or is it just legitimately what she's saying? Like there's some kind of squabble going on and my bat's sitting there, so I grabbed it.
Okay, that makes sense.
Yeah.
So my kind of second dumb question is, and I don't know that there necessarily is, but I always kind of want to make sure, is there anything that, you know, we didn't talk about or I didn't ask you about or anything that you think is important or anything that I should know? Because it's harder for you because you were there, and so I'm asking questions about
You're all
something
good, Lauren. I hope
didn't
you
even
feel
see.
better.
So I just want to make sure, like, I didn't miss something or anything that you think I should know about.
That was pretty much it.
Okay. And if you think of something, you know, in 5 minutes and tomorrow or whatever else, we can always talk again. It's totally fine. So, I talked to your mom about, we have some victim services people that work here. They're not cops. They're really good at what they do. So I really want your mom to talk to them, because I think it would be good that your mom has, and you guys have some, maybe kind of some extra support if you need anything, kind of go moving on.
Mm-hmm.
So I'm going to check in with your mom real quick, and if she's good to go, then I'm going to introduce one of them to you guys. That way you guys can talk before I take you guys back. Okay? Sound fair?
Yeah.
Okay. Do you have any questions for me at all?
No,
Okay. If you do, let me know, okay? Okay.
I'm just going to fast forward a little bit, everybody. I'm just kind of scrolling through my thing here. Yeah, I think that's it. Right here.
Hi. Do you want to come be with your mom? Sure.
Okay. Can you please hold? Hang on. Hold on 1 second, y'all. Okay, now let me find y'all. Okay, I was pulling someone else up. Okay, so there we are. Do y'all want to watch, because that really wasn't that long, do y'all want to watch the hearing from yesterday? Lori Daybell, obviously Lori Daybell's hearing. Hey, Northwest. Yes, we got the jury. Yeah, so anybody just joined or anybody's not, privy to it, whatever. Jury has been seated. Monday, we start. So there you go. So what we're going to do now is we're going to switch over. We're going to watch the hearing that Lori did. This is yesterday. Yeah, Tori, Jody Hildebrandt wants out. She is tired of being locked up, which brings up so many interesting questions, right? About her. I went back. I've got a video to do on that. I just haven't recorded it yet because I was like, all the things she's saying, it now makes you go back and look at her statement, or lack thereof, we should say. Okay, please help. Please help. Please continue to help. Drop a one if you get.
Are in the back as spectators, might not be able to be in the courtroom tomorrow during the jury selection process. I'm just letting you know. Let's talk about some of these. First of all, for the record, I did get the defendant's notice of objection to the jury questionnaire that was filed on March 20th. The defendant was objecting to, I guess, the phrasing of the allegations that the state has made, and then requested that the fact that she denies the allegation be bolded and underlined it in the questionnaire. I did get your objection. I guess de facto I overruled the objection and the questionnaire went out as proposed. Next I have defendant's motion in limine to preclude expert testimony of Daniel Coons dated March 10th. Let me ask the state. That's Detective Daniel Coons of the Chandler Police Department. Is he going to be testifying as an expert?
Your Honor, we did notice him as an expert in terms of his background and training and testifying as to trajectory. So we did that in abundance of caution, but we did supplement and provide the defense with the background of that. It was provided to the defense more than 30 days before trial. And defense has interviewed him since then.
What was the last part?
The defense has interviewed him since then.
Okay. So, Ms. Daybell, what's the objection?
So for 5 years, of course, he's been on the witness list to be a regular detective, and now he's being put on as an expert. I feel like to give his opinion instead of just stating the facts. So that was my main concern. I don't understand how the trajectory has anything to do with
Audra.
conspiracy. So I object in that way as well.
All right. Has he testified in that regard in the past?
Yes, I believe so, Your Honor. He has been trained in that area and taught in that area. And his relevance, Your Honor, would be because the defense has claimed a self-defense claim as well. It's relevant for that.
Can the state provide me what his opinion is, and does he have a CV?
He does not have a CV. We did actually put the opinion in the supplemental 15.1 that I filed, along with his
Okay.
The courtroom
I
looks so
believe,
big from
background and
this
training in
vantage
that as
point,
well,
right?
so.
Completely Senate Bay. I
guess let
agree.
me flesh this out a little bit more. Let me ask the defendant,
This is
you've said a couple
a
different things. Are
recliner
you saying he's
sofa.
not
Like not a
qualified
fancy one
as,
at all.
as an expert, or just that the disclosure came in late and you don't think his opinion is relevant?
Well, one, I don't think his opinion is relevant, but also the fact that he's named as a firearms expert. So I don't know if he took a weekend class and that made him a firearms expert. I don't know what his experience was with that. In his CV, it just says firearms expert. So
Did you ask him those questions? Was it you that interviewed him or your
Saucy.
investigator?
my investigator interviewed him.
Do you know if he asked questions regarding his
I'm not
background,
sure.
training, or expertise?
I'm screaming and I'm hollering,
So
Cindy.
I haven't listened to that yet.
It's an
so
electric
I'm not quite sure. My concern was that he was a regular detective on the witness list for 5 years, and then
It's
30
an
days before trial,
electric
he's now an
chair.
expert so that he can give his opinion. And I just thought that was my objection.
Well, if that was your basis of the objection on the timeliness of it, the state did comply with the rules as far as notice prior to trial and giving some sort of summary of what his opinion testimony would be. I'll take a look at it. It doesn't sound like we need any sort of Daubert hearing, but I'll take a look at it. So let's table that for now.
Did he just take a weekend class and
Now,
get labeled an
next
expert?
I have
possibly.
defendant's motion to
And-
disclose 404B evidence dated March 14, and the state's response dated March 23.
Oh, I don't remember,
I don't know
Stacy.
that
It'll
the
come to
evidence
me
that the
though.
state is offering to introduce necessarily 404B bad act per se, but let me hear from the defendant. You got her response?
I did.
All right. So what specific bad acts do you think should be precluded? Or were you just asking for disclosure of what they were actually intending on introducing?
I was asking for a disclosure of 404B that they planned on introducing at trial, and what I got was another theory of the case. So I didn't think that any of it was 404B relevant.
Well, I think I agree with you in so much as what was listed in their response, I wouldn't necessarily characterize as 404B evidence.
Man,
But
opening
you have
statements are
received
going
that
to be
and now you're aware
priceless.
of what they plan on introducing.
Somewhat
Okay.
correct.
I don't think I need to make a ruling on that. If there's evidentiary objections, hearsay, foundation, those types of things will be taken up when the state elicits or attempts to elicit that information. I have next defendant's motion to exclude state witnesses dated March 14 of 2025 and the state's response, specifically defendants requesting to exclude Nancy Jo Hancock, Christina Atwood, and Kay Woodcock. The state filed a response on why let me just make sure I'm looking at the right one. The state's going to offer some sort of testimony from these three witnesses that are going to talk about, it'd go toward the element of premeditation and or motive. So what is your objection specifically?
Mine, Your Honor?
Yes.
Oh, my objection was that after their interviews, after their defense interviews, that it came to light that their information came, well,
This is from
one
yesterday.
specifically came from Dateline, and then they called each other and their information came from each other. So
I guess I'm working a little bit in the dark. What information is that?
whatever they're, I don't know, planning on testifying about, none of them have personal knowledge of any kind of crime. So
The state's not saying they have personal knowledge of a crime. They have personal knowledge of things that may lead a jury to infer some sort of premeditation or motive. So what information is that? Let me ask the state. Or what's your offer of proof on why they're relevant?
With regards to Christina Atwood, she is a person who was present when the defendant was speaking about the victim being possessed,
Kat says they personally knew you were off
which
your
goes to,
rocker.
again, the motive of this as well as the premeditation.
That's the
And
truth.
those statements were made
Oh, that is the
months
truth.
in advance of the actual murder. With regards to Nancy.
So that's going to be
Is it
offered
really
as
an
some
all-male
form of
jury? You have got to be
admission from the
kidding.
defendant.
So that would be admission by party opponent. And that's personal knowledge.
Did you say that was Nancy Jo Hancock?
So that was Christina Atwood.
Christina Atwood.
Nancy Jo Hancock is the last person that saw the victim alive prior to that. What she knew about this was hearsay, but her statements to the victim of what he should do were her understanding and expression to the victim that he should tell the defendant that he had changed the life insurance policy to stop all of this from going on. So she both sees him the night before, is aware that he's there, and then she makes statements to him regarding what he should do.
Okay. And then
Kay Woodcock is the person who actually obtained the life insurance policy, which the state is alleging is part of the motive.
You know, she just punches air every
And
time she
she
hears the
also
Kay
has
Woodcock's
information
name.
relating to the victim himself. There are allegations again of the self-defense, the use of a baseball bat, so she can
Lori wants to have her
provide
Sharon Stone
background
moment
on,
with the jury.
the victim in that area as well.
All right. Do you want to have further argument?
Just the fact that this information that is supposed to be coming forward is not. All these witnesses are getting together and talking about all this and comparing all their notes and all these things beforehand. And then they're telling us that in these interviews. Well, I talked to her 100 times. Well, I talked to her every day. Well, she told me this. Well, she told me that. So their information is not firsthand. These witnesses are all coming together. They're all watching everything that goes on TV regarding this. And I would like them all precluded.
Okay, well, you're always allowed to cross-examine a witness about any biases they may have about those things that you've just talked about, colluding.
These things are
with other
heard through the
witnesses.
portal.
Those
They are
all
not
areas
fact.
of ripe for cross-examination, but they're not bases to preclude a witness. The court finds that based on the state's avowal that those three specific witnesses do have some minimal, although very limited, relevant information to provide and could be helpful to the jury in understanding the case. So the court will deny the motion to exclude the state's witnesses. Again, this ruling doesn't preclude you from any objections you may have to if they're testifying to hearsay or something like that. Next I have is
Lori's like,
there a
what just
Mr.
happened?
Eaton here appearing?
Oh, Mr. Nate.
Your Honor, Matthew Kelly, I represent Mr. Eaton.
Okay, you filed a motion.
Oh,
over the
that's right. I
weekend.
remember him.
Mr. Eaton or someone that he works with filed a motion. Mr. Eaton was, let's address that now while we have people here. Mr. Eaton was listed as a witness by the defendant. Mr. Eaton apparently is a reporter in Idaho and based on the filings, believes he doesn't have any relevant information and shouldn't be listed as a witness. So let me ask the defendant, what relevant information would Mr. Eaton have? Why is he listed as a witness?
Go on, Lori.
Well, I just got this last night, so I haven't had time to read all the things that he's claiming he doesn't. But there's several things off the top of my head that is relevant. Right now, one of the things is it's different now, right? Because he's had this off the record conversation with the prosecutor. And he's kind of made himself a witness. He's kind of made her a witness.
How so?
In the sense that if this is not prosecutorial misconduct, then one of them is going to have to testify and talk about how it's not.
Let's back up. How is he
Okay.
a witness to this trial? How does he have relevant information? Relevant information means a witness has testimony that makes some fact in the case more or less likely. So how does he have relevant information for what this case is about?
Okay, so initially when I put him on my witness list, my intent is because I do not know what the state is going to put on in their case in chief. And so I was calling him as a witness for the purpose of impeachment, laying foundation for interviews, rebuttal to whatever that the state might put forth, because he has interviewed almost every single witness on their witness list. And if they were to say something contrary to what they said to him on a public thing, then I would use him to lay a foundation for interviews and for impeachment. So that was my initial, in calling him. I found it funny when I read the beginning of this, he says that it seems to be clear attempt by Mrs. Daybell to use the rules of criminal procedure as a pretext simply to keep me out of the courtroom and interfere with my ability to report. So I had to laugh at that because it hadn't even occurred to me that he wouldn't be able to be in the courtroom if he was a witness according to 615. So that wasn't my intention. It was never my intention to do that. It was just to have him on hand if we needed to do that.
Really, Your Honor, he made himself a witness mostly. Mostly. Mostly he made himself a witness. Mostly. It's giving. Whoever did that comment at one time, it's giving. They mostly come out at night. Mostly.
All right. Mr. Kelly, right?
Yes, Your Honor.
Mr. Kelly, in theory, it sounds like if a witness said something different than they reported to Mr. Eaton at some point, I guess in theory, she's right that Mr. Kelly could be called as a witness to impeach someone, but that's only allowed after the person's confronted with the actual statement that was made, and if they then deny that statement that was made. Do you have copies of his interviews and transcripts of interviews that you might want to impeach someone with?
I've been watching most of the interviews and I take my own notes, so yes.
Go ahead.
Your Honor, two things. One, excluding Mr. Eaton under Rule 615 would be a violation of his rights under the First Amendment to attend and report on this very public trial. But more importantly, Your Honor, if Mr. Eaton were to be called as a witness, the party calling him would have to comply with ARS 12-2214, which has very stringent requirements for subpoenaing and compelling the testimony of a journalist about information that that journalist has obtained in the course of news gathering. As we state in our motion, we don't believe that there is any way that Ms. Daybell can meet those requirements, but I would suggest that if she wants to call him as a witness, she would absolutely have to follow the requirements of the subpoena law, and we would then have an opportunity to challenge that. But we don't believe that there should be any reason for Mr. Eaton to be excluded from the courtroom.
All right. I'm just thinking through this.
Also, the way that she comes at everyone, like in this, like even with her tone, but then the way she's doing, like they're all out to get her. Like they have all conspired against her and literally just made all this up out of thin air. And she has that like entitledness to it or whatever. Like, you know what I mean? Like they've all talked. I don't know what they're going to testify about. They don't really know anything. Like that whole vibe she gives off.
Problem. If a witness got on the witness stand and said something different in testimony than you saw on an interview with Mr. Eaton, you would then play that interview. You wouldn't even need Mr. Eaton to do the impeachment because you could impeach them with the interview by playing it for them in court.
She's like,
or
what?
Something like that. So now that I'm kind of thinking it through a little more, I'm not sure.
And I wouldn't need him to lay that foundation for the interview?
I'm really trying not to give you any legal advice because you are acting as your own attorney, but if the witness admits that's them on the interview and that's their statement, that is foundation. So
he's interviewed law enforcement, almost all the law enforcement that's going to be, up here on the stand. So it's not just witnesses, it's law enforcement.
Well, when I say witness, I mean generally any witness, regardless of their occupation. So I don't foresee, I see it in only the narrowest of situations where he could even be called to as an extrinsic person to testify about the impeachment. You'd have to jump through a number of hoops before that, as far as presenting the witness what the statement is, and depending on whether they admit or deny that it's them on that video or interview or whatever the case may be that you're referring to. But I'm inclined to strike him as a witness at this time, allow him to be present if he so chooses in the trial. But then again, if you wanted him as a witness, you would need to subpoena him. But at this point, I'm going to strike him from the witness list and permit him to be in the courtroom. If there's a situation where you think something has happened during the trial where you think he should be called as a witness, I guess we'll cross that bridge when and if it comes.
Oh, she don't like that.
We could just call him up from the back.
Well, we'll address it when and if it comes, yeah.
And Your Honor, I would ask that if that were to occur, that I would be notified and given a chance to appear and be heard.
Well, everyone will get a chance to be heard if we cross that bridge. I just don't see us crossing that bridge, but I could be wrong. So at this time, it's sort of striking Nate Eaton from the witness list. He can be present if he so chooses in the courtroom.
Thank you, Your Honor.
All right, thank you. Let's go next to the state's motion to preclude media from displaying or disclosing phone numbers and email for witnesses and victims. I guess I have no problem granting this in concept, but let me ask the state, are these people are going to testify, this is my phone number or this is my email, or it's going to be displayed up as part of the evidence on the screen, or both?
Your Honor, it would be both. Some people would have to testify as to their phone numbers or emails that would also then to establish the foundation of then conversations that are on text messages, emails, iCloud accounts. So my concern obviously is there are both victims whose information could be displayed up there, and I think the Constitution allows them to request that that not be displayed. But additionally, just for safety concerns, given the high profile nature of this, for witnesses who have, several of them have attempted to not be part of the media and have not given interviews and would not want their information to be out there, given that this is being live streamed, having their phone numbers or email addresses live streamed out there to the world, I would ask that that not be done.
All right. Does the defense want to be heard on any of that?
No, we agree.
So we're not actually being live streamed, but there's a 30-minute delay order on broadcasting what's in the courtroom. I already have a protective order that jurors can't be broadcast in any way. And I have an order that the feed can't broadcast sidebars that we might have. So I'm going to order that the feed also, to the extent you can see it visually on an exhibit or something, they shouldn't film someone's phone number or email. And then I don't know if the right person's here. Do we have the ability to, does the media have the ability to bleep out or silence if someone says my phone number is 480 blah blah blah? We'll find that out before we start the trial, but
Thank you, Honor.
that'll be the order. As for anyone that's doing print or podcasts or anything like that, you're prohibited from reciting an entire phone number or an entire email. You can use the area code, or you can use a couple digits at whatever, at live.com, at outlook.com, but I don't want their emails broadcast or reprinted. Let's go to state's motion to preclude Lonnie Dorkin and precluded and preclude noticed witnesses. Did Mr. Dworkin ever get a report prepared?
Not that the state has received.
Do you know?
Lori's like, listen, I can't get up and come to you. I've got a shock belt on. They got me real good about 10 minutes ago. Yep, that was me on the floor, shaking about like a little squirrel. Yep, that was me. I got out of line. They put me back in line. Oh, yeah. Oh, yeah. Oh, it hurts.
Okay. Your Honor, most likely, we're having an affidavit sent over from Mr. Dworkin tonight. He has found a discrepancy in the information that he downloaded and the information that was turned over initially by the state, and he wants to explain what that is and how that will be relevant. So if we get it tonight, we'll forward it immediately to the state, of course, tonight. He was working on a bunch of cases and he's doing the best he could to include our case and get it done as quickly as possible as when he was assigned from OPDS.
Well, at this time, I'm inclined to preclude Mr. Dworkin, granted something pretty extraordinary happening. I offered you a continuance last time we were in court in order for you to explore that possibility. You declined the continuance. So it's any disclosures late at this point. I'm not going to slam the door on it completely because he may or may not have anything that actually ends up being useful.
Thank you, Tammy.
But at this, if depending on what he actually has, we can talk about it. But at this time, he's likely to be precluded as a witness because the state wouldn't even have an opportunity to have their own witness or rebuttal witness look at something prior to trial. But again, depending on what you have, we can talk about it again.
Okay.
The rest of your witnesses, we've already talked about Nate Eaton. I don't know if we need to go through each and every witness, but I think where I need to start is if a witness hasn't been served with a subpoena to appear in court, there's no requirement for them to show up for your trial.
Oops.
If they have been served, they would need to submit to an interview with the state in advance of their testimony. And then the third aspect is they need to have something relevant.
This was Lori's moment. You know that movie, Romeo Shell's High School Reunion? This was Lori's moment right here, being like, I can't believe we forgot to make up what business we own. This was her moment. The one key ingredient to making everything happen. Subpoena the witnesses. Ain't nobody showing up.
To testify about, which relevance,
thinks
I told you
Adriana-
a little bit ago means they have a testimony that's not based on hearsay, that tends to make either a fact more likely or not. So why don't we go through, I'm trying to compare your witness list to the state's motion. Let me see here. So Nate Eaton, as of now, is not a witness. Next, we have I don't know how to pronounce her name. Is it Viasia?
Vicia.
Vicia?
Ita Iha.
Is this one of the ones the state was able to get a hold of?
No, Your Honor, we did call the numbers and left voicemail. I've not had any response, and it's my understanding that when I interviewed the defendant's investigator, Jeff White, he also was unable to speak with her.
All right. What about Gabriel Bonilla?
Your Honor, I had an update on that one in the sense that on Saturday, so when the state interviewed, again, Jeff White, the defendant's investigator, he had not been able to speak with Mr. Bonilla. I also called and left a message on the phone number that I received from the investigator. On Saturday, the attorney for Mr. Bonilla called me, and Matthew Ballard, who represents the Church of Latter-day Saints, he advised me that Mr. Bonilla has not been served with a subpoena, but I did not speak with Mr. Bonilla or was not given an option to speak with him.
So we don't know if that person's been served or if they have relevant information.
According to the attorney, Matthew Ballard, he has not been served.
All right.
Oops.
What about, well, why don't I just ask the state? I've got your supplemental and your other one. I know you've actually talked to a few of these people on the phone.
Correct.
Is there anyone on this list, and I'm looking at the defendant's supplemental 15.2 filed March 12 on page 2, there's a number of witnesses listed out. Is there any on this list that you have talked to that you don't object to being called?
Your Honor, I think that there is potentially minimal relevance from Summer Shiflett.
Shizlet?
I think that's a misspelling of
Oh.
her sister's name.
The Shizlet. The summer of the Shizlets.
I think there's potentially minimal relevance for Janice Cox, her
Sure.
mother.
Okay.
Adam
wonder if
Cox
they'll
is
show up.
actually on the state's witness list, so we don't object to him. I did speak with Zachary Cox. I'm not aware of any relevance as to this case from him, but I did speak with him.
I see in your pleading that he advised you he's not been subpoenaed.
Correct. Everyone I've spoken with has not been subpoenaed.
All right.
Ouch.
Your Honor, our subpoenas are with OPDS right now, and they should be being issued currently. The state talks about in their response, like the state is claiming trial by ambush from the defense. Trial by ambush. How is the defense trial by ambush when they have interviewed every single one of these witnesses before in the last 5 years since this case started? They've interviewed every single person that has been on there. They have written, transcripted interviews and video interviews of all of these people. And so how they are relevant, these witnesses will testify if and when they are needed to add additional facts or fill in the blanks that the state will no doubt leave out in their case in chief, and they'll be called accordingly. I need them to lay perhaps foundations for evidence presented by the state. The same with Lonnie Dorkin. I need his testimony will be required if and when it's necessary to rebut digital information that the state will bring forward during trial. I feel like the state is trying to say, okay, if you want your speedy trial, guess what? We're not going to let you defend yourself. Guess what? You can't have the expert.
Who
And
is that,
guess what
Noah?
else? You can't have
Did Sarah Boone
any
herself?
witnesses. You can't have anybody speak in your
No,
behalf. So
did Sarah
good
Boone
luck.
shoot me out?
Have a nice day.
All right. Well, that's why attorneys sometimes take a long time to prepare for a trial, because they need to give notice of what all the testimony their witnesses are going to give. They need their experts to prepare reports. That's why your prior attorneys and your current attorneys were asking for more time to prepare the case. So you can't really have it both ways, that you want your speedy trial rights, but you don't want to give notice to the other side of what your evidence is.
I don't not want to give notice to
Ooh.
the other side, but the limitations at the incarcerated state where I am, and the limitations with OPDS of getting Lonnie Dworkin late in the game that they did, I've done everything in my power as a defendant to prepare the state and to give over everything that I could do within my power, with the limitations that I am an incarcerated person at this maximum security prison jail.
So when you say,
And I shouldn't be able to represent myself because of that fact?
I
That
didn't-
negates my constitutional right?
didn't say that. All right. I said that sometimes there are reasons to not go forward to trial as fast as you want. All right. So when you say
He just
things
moves
like
right
they're gonna
on.
fill in the blanks, that makes it really hard to assess what their relevant information is.
They have relevant information to a lot of factors that I got in the 404B information. For example, the life insurance. My father is a life insurance salesman. He worked with Charles on getting both life insurance policies, my $2 million policy and Charles' $1 million policy.
She's still
He
mad
also
about
tried
that.
to sell my insurance policy after Charles passed away. He also told me to go to call the insurance policy and said how to do that, how to call
Thanks,
them when you're the
GMJ.
beneficiary. I didn't know how to do any of those things. He has relevant information to that. My sister has relevant information to my brother Alex Cox and the whole situation of what happened on July 11th. These people have relevant information to the state's case, what they're accusing me of. There's very relevant information from a lot of these witnesses.
Come here.
So what I'm struggling with
Look.
is you just saying that it's relevant doesn't actually make it relevant. It may
Hey,
be
man.
relevant. I'm trying to find out the relevancy.
Look,
What you said
sweetie,
about
come
your
here.
father being an insurance salesman and selling policies, that sounds relevant. It could be relevant to me. Who's your father? I don't know who your father is.
Barry Cox.
All right, Barry Cox. It sounds like even from what you're saying, though, you're not, depending on what the state produces at trial, you're not sure that these witnesses would have relevant information. It just depends, is what it sounds like.
Whatever they put up in their case in chief, am I not allowed to try to defend myself against that?
You're absolutely allowed. I'm just trying to figure out, I'm sort of a gatekeeper and I need to make sure witnesses have relevant information. And just like you have the right to interview all of the state witnesses, excluding victims' rights, people that can deny having an interview, they have the right to interview all your witnesses prior to trial so they can have an idea of what those witnesses might say. On the
Bye,
witness.
Tori.
I understand that, Your Honor.
So
They also have already interviewed all of them.
I'm not talking about police interviews or interviews that may have been done years ago. The prosecutor has the right to interview any witness prior to them taking the stand, just as you do. So I'm not sure the best way to handle this, other than maybe we should take it up as we progress through the case, but
Your Honor,
some of
my-
these people may or may not be even served.
Yeah, my concern is obviously.
He keeps
I have
bringing
been
that
able
up.
To reach these people, I've made my good faith effort. I've been told both by myself in attempting to contact them, as well as the defense investigator, that they've been unable to reach them. So it seems to not be following the rules of procedure or evidence to then bring up later on if they perhaps find these people at some point. Then the state can try to, at that point, preclude them. When the state talks about a trial by ambush, it is in fact that. When the defense investigator themselves cannot find these people and are still looking for them in trial when they've had at least, we'll say, 4 months to try to find them, I think that at this point, precluding them is proper.
Well, I would preclude anyone that doesn't submit to an interview with the state. I kind of want to punt this a little bit just because if there's people that don't end up getting served, don't end up showing up at court, they can't find, then we don't need to waste our time talking about whether or not those people have relevant information because they're not going to be here and they're not going to testify. So I'm putting the defendant on notice that if these witnesses aren't served, if they don't submit to interviews, they're going to be precluded. Even if they submit to interviews, I may have to make a determination whether their testimony is relevant or not. So again, we're going to, I think, have to cross that bridge when it comes. The state did say that they concede that some of the witnesses, Adam Cox, Janice Cox, Summer Shiflett, may have some minimally relevant information. The rest of these, I think we're gonna have to take up maybe on a piecemeal basis, but I don't want it, it's not gonna be a situation where you're ready to call them in as a witness the morning of, and then the state they haven't been presented to the state for an interview prior to that. So keep that in mind when coordinating with your investigator. If he gets them served and they're actually going to be called at trial, they need to submit to an interview in advance of their testimony.
Your Honor, I understand that, and I am limited in what I can do. If I could call these people myself, they would answer my call probably, and I could have this discussion with them, but I'm
so
going
sure.
through the limitations that I have at the jail through my paralegal who's working overtime and my investigator who's working overtime to try to do everything to help me prepare for trial, as they have other clients as well that they have to do things in a timely manner for. So we
Well,
are doing the best that we can.
okay. All right. We next have defendant's motion to dismiss for violation of confidential communication and the Sixth Amendment dated March 18 of 2025 and the state's response. Let me ask the defendant first if you've received the state's response.
I did.
Did you say you did or didn't?
I did.
Okay.
Yes.
If you have an attorney in Idaho that is working on an appeal, it appears that the information that was turned over by the jail was some pretty innocuous messages about trying to set up the legal line to talk to you on a confidential line. And really that's about it. So how does this arise to some sort of nefarious interception of things? Because it was put on a public chat system that the jail uses. You know it's not confidential, and you're told it's not confidential. And then even if I look at the substance of the messages, there's really nothing in the messages that would arise to some sort of confidential communication, just trying to set up a meeting and get the unrecorded legal line set up.
Who's saying that they're not confidential?
Oops.
Well, the
Who's
jail,
telling me that they're not confidential?
your own attorney, it looks like. Here's a message. I see that they came and got you. I'm working on getting a confidential attorney line set up. The implication being that this message is not confidential. The next one, again, just checking in. Hope things are getting a little better for you. I'm still working on getting a legal line set up. The implication is that these are not confidential.
Okay, so then he received a letter from MCSO that said, your phone number is now confidential and arranged for confidential client privilege communications. So
Phone calls.
no, it says this phone number is connected to that. So from my perspective, when I call someone on the tablet or when I text someone on the tablet, it goes to their phone number. So all the communications after the date of the exhibit that we put in our motion, when he got that letter from MCSO that now all of your things will be confidential.
Okay.
Now they will be confidential. So my understanding, and I'm the only one that can waive that privilege, right?
And I think after that, when his line was approved, there were no other disclosures of messages between you and him, correct?
No, there are.
You received other disclosures of intercepting messages between you and him?
So those go up to the 24th of January.
No, the only thing I saw was up to, I think, late December of 23.
Okay, so there are confidential things that are in our communications because I was not aware that after he received that there were not. So the prosecutor who obtained these her protocol would not be to stop and ask the court for some guidance on this, maybe do an in-camera review. If she's subjecting herself to client privileged communications, instead of reading them and finding out and assessing for herself if there are anything in there that's confidential information between me and my appeals attorney, I have no other way to communicate with him when I'm in this incarcerated situation because I was brought here to Arizona to deal with these charges. So it is a problem. It's a problem that she took them. It's a problem that she got them from MCSO. It's a problem that she read through them. It's a huge problem that she put some of them into her motion and now his IP address is exposed to the public, which is a federal offense. There's a lot of things wrong with what has happened here.
And I declare a
reminded me
mistrial.
That when his number was approved, he then sent messages from different IP addresses instead of that phone number that was privileged. So he's the one that disclosed or violated the confidential nature. I don't see that any of these, I'm going to call them inadvertently intercepted messages between you and your appeal attorney. I don't see that they're being used in any way by the state.
Just the state reading them as a violation of the client attorney privilege.
Well, not if they're not done through a privileged setup the way that they were supposed to, which he even acknowledged.
My understanding from my perspective was that that phone number was now privileged. The way it comes to me on the tablet is I text that phone number or I call that phone number.
Correct.
So,
if you're communicating through the phone number, but if he has it set up where the messages aren't being sent and received actually through the phone number, but through different IP addresses, the system doesn't know that they're privileged because they're not being sent and received through that privileged number.
but I didn't know that. There's no way for me to know that from where I am in my cell. There's no understanding for that. I assumed he was just getting them on his same phone that we were having client attorney privileged communications. And is the state giving these to Idaho? Do these get dispersed out? I would like to know that. Where are these going? They're getting them from MCSO. Is there a subpoena to get these from MCSO? Is there a warrant to get these from MCSO? I didn't see anything.
Oh, she's got a lot of
that
questions
warrants
now.
them getting them from MCSO in the first place.
All right, let me hear from the state.
Your Honor, I think that the state's motion really covers the law under this. The defendant and her attorney were provided with information, whether or not she understood it or not. Her attorney understood that it was phone calls that were covered. So it's not just the defendant who is not complying with following the correct procedure to utilize the set up attorney-client privilege means to communicate. In this case, the state, obviously, I disclose those before I even look at them. I understand that they are statements by a defendant, and I believe that they are to be disclosed under Rule 15. And so before I even look at them, I send them to the defendant because I don't have the option of not providing them to her since they have been obtained. I think if you apply the case law in this, the defendant cannot meet her burden to show that there's any legal advice in these messages. There's no privilege in them. The messages are asking to set up times to call and to speak.
Are the three, I think it's 3 messages that you included in your response, are those all the messages?
No, Your Honor, there are other messages, and we do say that tablet messages between Ms. Daybell and Mr. Jerem do not end on December 28th. They continue.
And there is privileged information on them going forward. And the state is basically testifying for my attorney now. She just testified for my attorney that he understood that that these were not privileged communications. Where does she understand that where is she testifying for my attorney?
Well, I think because the context of the messages say, I'm trying to schedule a time and I'm trying to set up a confidential line, meaning
That was
this is not
before.
confidential.
That's right. He said it wasn't confidential before MCSO gave him a letter saying your phone number is now confidential. Your phone number now has.
Okay, I'm not going to keep rehashing this with you. The fact that he's using different IP addresses and not messaging through the actual phone number that's protected, I think is part of the problem. So if he's not using the program correctly, that's an issue you need to take up with your attorney.
How is
This
he
would be-
using it incorrectly?
I just told you. He's not messaging through the phone number. He's using different IP
How can
addresses.
you message other than the phone number? I don't understand that.
I don't understand that either, but if it was from the phone number and it's for his cell phone, for example, it would be the same IP address for each communication. There's like 4 or 5 IP addresses.
Where are the IP addresses coming from? They're given to you by the state?
They're right there listed on the messages.
I'm just saying, where are they obtaining those from?
From your attorney's messages to you?
From MCSO?
Yeah.
Did they get IP addresses for every single person of every single message communication on the text from MCSO?
Well, it's listed on the messages, so I assume so. It says Craig Durham, and then under it is the IP address from the device that's being used.
Okay, and then Ms. K is reading all of these messages and they're not privileged. Is that what you're coming to?
They're not privileged if you're not using the program or your attorney's not using the program correctly. Okay, they're still not going to be allowed to use any of these messages. What I'm saying is they're inadvertent disclosure by MCSO because someone's not using the program correctly doesn't mean that they had bad faith in how they got them. They made
How is he using it incorrectly?
I don't know how else to explain it to you. I've told you 5 different times now. So he's not messaging with the phone number. He's messaging from different IP addresses.
Okay, can I ask if these messages are being disseminated anywhere to Idaho, to the prosecutors in Idaho? Because it's definitely affecting my appeal if that's the case.
I don't know.
Have not been sent to anyone other than the defendant, Your Honor.
All right.
They're going to need an expert witness in here for this.
There was some communications I find that were intercepted between.
So y'all, real quick, the white dog is Jake. This is Matt's. The one who was just here, the kind of, brown and white one, he was now on my legs because he's starting to get mad at everybody. That's Oliver. You can't see him now, but Bo's right here. And then Luke is doing weird little Luke things somewhere.
Ms. Daybell and her attorney. The state's not to use those communications. They're not to disseminate those communications, but I do find that they weren't purposely sought out by the state. And that dismissal isn't the appropriate sanction if there is an appropriate sanction. It's ordered denying the motion to dismiss for violation of confidential communication. All right, then we have defendant's motion to dismiss for prosecutorial misconduct dated March 21st. Let me get that.
She didn't like that. Nope. Luke just showed up.
And
He's
state's
now
response.
requesting play from all the dogs.
The
Oh,
motion to
that's
dismiss
cute,
for
Slow.
prosecutorial misconduct was filed on March 21. The response, I don't see a date on the response, but I do have the response. Did you get that response? Ms. Daybell, did you get that response?
I did, Your Honor.
She was like, sorry, I was in the portal. I had to take a call in the portal real quick. It was Chad.
So your prior attorneys had, actually, let me back up. The state filed a motion back in, I think it was September of 2024, asking the court to preclude your defense team at the time from making public records requests through Gilbert and/or Chandler police departments. I denied the state's request, saying that the defense is free to do their investigation and make public records requests through appropriate means. So that's part of your,
Yeah, that's Luke.
complaint
Well, now he's run
that
off.
they didn't provide those public documents to the defense. That's sort of a civil issue, I guess, but let me hear your argument on that.
That isn't really the complaint itself.
That's your first paragraph.
I know, but the complaint is that,
I'd like to take each allegation and deal with them one at a time. That's your
I
fir-
understand
that's
that.
your first
My
allegation.
complaint is the interference by the state, Ms. K in particular, in stopping that and interfering with us trying to investigate and do our own investigation. It is a violation of the constitutional right and due process. And she did do it, and she did do it purposefully. And then after she did it, and we weren't allowed to have anything from either of the police departments, then she filed her motion. And then later, the day that I was Rule 11, that is the day after when you said that you denied that motion. So I don't know what she did or what she said to Chandler and Gilbert to stop them from giving us any information. But as soon as we put in a request, we were cut off. No information. You can't have anything. That's when I was trying to, the big video that we're trying to get in Gilbert, that's what I was trying to request. I tried to request that myself because I would have my investigator go and explain what that was and why we didn't have it. And so we were precluded from doing all those things by the state. They should not be interfering with that. That's one of the reasons why everything has taken so long. We haven't been given things we've asked the state for. We haven't been given them. We tried to get them from Chandler and Gilbert. We can't get them from them. She's stopping us from getting from them. How are you supposed to put together a defense?
So when your prior defense counsel put in that request back in September, the state says that they obtained those information and gave it to your attorneys on October 1. So why are we waiting until March to address this if you had an issue with that?
I have had an issue with it the whole time. I've
But
been
why
talk-
didn't you file why didn't someone file a motion back in after, December, November, January, February, saying they had an issue with this?
I did. These are in my motions to you for specific discovery. I discussed this exact problem.
Okay. Well, now you're saying it arises
I
out of
mean-
prosecutorial misconduct.
It is.
She is mad. Not
This
really.
is the first I've been made aware of that, as far as I know, that the police department never honored the public records request. If they don't honor a public records request, there's a process to go through regarding that.
Which is what?
I'm not going to give you legal advice.
I mean, she's talking to him
Your second allegation.
like she got a
of
cold
prosecutorial
dish
misconduct,
for
we've already
course
kind of
3,
dealt
and
with,
she
that
wants to speak to the
distributed
maitre d'.
the state distributed attorney-client privileged
Oh,
communication.
thanks,
We
Kate.
discussed that. The next one is legal advice to defense witness Nate Eaton. We've somewhat discussed that, but I think their motion, the state says that they simply notified him that he would need to be served with a subpoena to have to appear in court. So how is that improper?
It's taking her word for that that's what happened. She's not under oath saying that that's what happened. Nate Eaton's not here to testify that that's what happened. They're the only two parties that are there to say that that is what happened. So that is my problem with it. I would like for one of them to get on the stand and say exactly what happened in that conversation and that she wasn't giving him legal advice. How do we know that she wasn't? It's a very curious situation that he called her and then he writes in his motion this statement that obviously comes from Ms. K. She seems to be a clear attempt by Ms. Daybell to use the rules of criminal procedure as a pretext simply to keep me out of the courtroom and interfere with my ability to report. We also don't know if he told her, don't come to the March 18th hearing because that's when they're going to serve you with your subpoena. So all these things come from there and we don't know who's saying it. And you're just taking her word for it like you took her word for, oh, there's only 6 emails and there's no other emails. You're just taking her word for it as an officer of the court. And I think that she should have to be sworn in.
Well, you want me to just take your word for he must have gotten these things from Miss K. Okay. Just because his motion says
He gives it right
thinks
back
that
to her.
you're noticing him as a witness to keep him out of the courtroom. I don't know why you take the jump to that is coming from Ms. K as opposed to his own volition. He also hired an attorney that said the same thing.
She don't have much to say about that now, does she?
Even if she had said you need to be served with a subpoena to have to show up in court, that is not an ethical violation.
Thank you, Kate.
Well, giving legal advice is an ethical violation. Is that correct?
Stating what the law is not an ethical violation.
Go on, Zapper. Go on. She's at a 10. Knock her
She
down.
said,
She's
"I
at a
don't
10.
think
We
you
need
should
her
show
at
up
8.
court." Even if you're subpoenaed or something like that, that could be an ethical violation, but we don't have that.
How do
All
we
right.
know we don't have that? That's my question. How do we know what went on in that conversation if it wasn't recorded? Aren't witness
You can
interviews
interview him.
recorded?
You can interview Mr. Eaton. Your investigator can interview Mr. Eaton. So when and if you get that information from Mr. Eaton that something nefarious happened in that conversation, bring it up then. But you're jumping to conclusions. You have the right to interview any witness. Okay.
not a witness anymore because you just precluded him?
All right.
Nanny, nanny,
You
boo
can
boo.
interview him. You can
That's
have
how she sounds.
Your investigator interview him.
So
There's
even
a-
though he's not a notice
go on,
witness
send
now,
her
we can
about a
still
20
interview him
volt.
and try to find
Make
this
sure it's
information
working.
because
Ready for opening
we can't get it
statements.
now? Is that what you're saying?
Sure. Have your investigator call him. Ask him about the conversation. At this time, I'm going to, based on just the pleadings, I'm denying the motion to dismiss for prosecutorial misconduct.
You hear, of
All right,
course.
609 motion.
Of course he did.
The state's alleged a total of 7 felony convictions in the state of Idaho. Under Rule 609,
This is the equivalent of
court
best in
finds that
show, but this is like best in court. If you
limiting
know
the
what I'm
number
talking
of
about
convictions and
for the
the
mockumentary.
nature of the convictions to be appropriate as to not be overly prejudicial. There is an interest in allowing a jury to know that the defendant's been convicted of at least one felony. But let me hear, I'm inclined to probably limit it to 2 felonies in order that they be sanitized. Does the state want to be heard on that?
Your Honor, I do believe that the court should allow for at least 3. There are multiple dates and multiple victims in those and multiple different distinct incidents.
There's only a
and
few
I
more
think that
minutes
it would
left,
be
y'all. We're almost there.
appropriate to, when we're talking about the credibility of the defendant to allowing in 3 of those?
I looked at the date ranges and I looked at the actual counts, and some of the counts, obviously the laws are titled differently in Idaho, but there's a couple of counts that specifically have what I would call dishonesty built into the name of the conviction, the first degree murder and grand theft by deception. Those are counts 1 and 3 specifically. And again, these only become relevant if the defendant chooses to testify. I did read the defendant's response asking that all of them be precluded. Let me hear from the defendant.
One second, Your Honor.
She's, look, come here for a second. Okay, look, I just soiled myself. Is that gonna electrocute me with this belt? Okay. Mm-hmm. All right. Yeah. Mhm. I didn't know. Yeah, I was afraid. I didn't want to raise my hand to go to the bathroom. That right was taken away from me. So here we are.
Your Honor, I haven't had a time to,
Jenny says, I don't sound bitchy, do I?
I wasn't planning on talking about the 609 today, so I'll just refer to my reply.
Well, we can table it till later in the trial because again, it doesn't become relevant unless you choose to testify, but you know my inclination and what the state's argument is.
Okay.
This morning I handed each side proposed preliminary instructions. We don't need to discuss those now, but depending on tomorrow how far we get in the jury selection process, maybe you can be prepared to tell me if you object to any or if there are additions or corrections that need to be made.
He's
All right,
exhausted.
I think that's going to be it for today, but let me check with the state. Is there anything else we need to address today?
I think just for the record, Your Honor, in terms of allowing in witnesses, the gallery, I think that you had indicated you would reserve 1 row for the next of kin.
Yeah, let's discuss that. We're going to put up signage after we complete jury selection. So the first row on both sides behind defense counsel and behind the state will be reserved for immediate family members, next of kin, those sorts of people, relatives. The very last row on both sides will be reserved for media. And then the middle rows in between those two will be kind of a first come, first serve general public viewing area. Any questions about that?
I do just want to make sure that, assuming we're leaving on the defendant's mother, father, sister,
Well, if they're potential witnesses, they won't be in here.
the state will be invoking the rule of exclusion.
Do you understand that, Ms. Daybell?
I do.
All right.
I do.
So as long as people that we haven't already addressed other than Mr. Eaton remain on the witness list, the rule of exclusion would be, in fact, it means that they won't be allowed in the courtroom except for your investigator can be in the courtroom. And they're precluded from talking to anyone about their testimony or other testimony until they're released as witnesses. Anything else from the state for today?
I don't believe so, Your Honor.
All right. Anything from the defense for today?
A couple of things, Your Honor. We need to discuss the,
How the division would like the media exhibits.
What?
How the division would like the media exhibits, if we're presenting recordings or audio, individual flash drives for each exhibit. There wasn't.
Depends on how you're going to present them, but I would say, yeah, probably one
Trial starts
flash drive
Monday.
per recording or exhibit.
And then I'm guessing 3 copies, one for state, one for.
I don't know that you need copies if you've already disclosed it to them. Just tell them what it is when we're marking it, and tell the clerk what it is with the description, so it's clear on the exhibit list which exhibit is what.
one more thing, Your Honor. I wanted a clarification. In your minute entry dated the 25th regarding the defendant's motion to remove restraints. So my understanding when I read what was from MCSO, and then you put in here, however, at the sheriff's discretion, 1 or more armed sheriff deputies may be positioned near the exits. So what their recommendation was the minimal amount of restraints, meaning if there was going to be an armed guard, then they would not have to do the belt. So I was confused by and wanted a clarification on what you were actually ordering, because the DOs had a question about it with me this morning. So
I ordered that you don't have to wear the leg restraint, but that you do have to wear the rack belt, because that is not going to be visible to the jury. The leg restraint's a little more cumbersome and visible, and since you're representing yourself and you're going to need to approach the podium and those sorts of things, I ordered the removal of the leg restraint. You will, though, wear the rack belt. And then I said it's up to the sheriff's office if they want to. They can position a couple deputies in the back if they want additional deputies.
well, their recommendation was that you wouldn't have to use the belt at all if they had the armed guard.
I read their response.
Use the
and their
belt.
recommendation, and that's my order.
So what is it exactly?
What I just said.
That you have to wear the rack belt, but not the leg restraint.
And that they will or will not have armed guard?
It's up to them.
Okay.
The rack belt, you know the WWE wrestlers, how they wear those big
All
like
right,
belt
so tomorrow we're going to
things?
start at 10:30.
That's what it sounds like
with
to
going
me
through the
when he says
answers
rack belt. It sounds like a big thing.
on the questionnaires that the walk-in jurors will fill out in the morning. And then in the afternoon, we'll have in-person voir dire of those potential jurors. The court's going to seal the FTR tomorrow for the portion of the in-person answers of the jurors, which should be from 1:30 on. All right, we'll be at recess.
Well. Quite the fiery little evening. So, yeah, that doesn't get old. Lori really doesn't. I mean, she's, for lack of a better word, interesting to watch. You know what I'm saying? And I don't mean that in a positive way. It's just, she's just interesting to watch how rude she is to the judge, to the state, the stuff she's doing clearly, and this is her anyway, whatever. Anyone representing themselves is out of their league, which any of us would be, right? You know what I'm saying? Like, unless we're lawyers or whatever, but it makes for interesting TV, if you will, because you're like, okay, how are they going to do this? And what's this going to do? But then when you have an attitude like hers, it's like, I mean, the way the judge was being very fair to her, he gave her attitude back when he needed to, but he was like going to sit there and be like, you can talk to me all you want. You're going to get shocked on day one. Go on, get it out right now. You're going down on the phone opening statements. He was like, look, here's how it goes. He's like, we're going to get that belt out, all right. Don't you worry, girl. We're going to get that belt. Yeah, he's just very even kill, right? Very even kill. just so here we are, this is what we're doing, you know, no, just nothing really. Yeah, and Susan brings up a good point. Susan says, I think her trial advisor will have to make her turn it down when the jurors are there. I would think so and hope so too. You know what I mean? Because like, but again, here's the whole thing. So again, I don't think Lori's like trying to get like justice or whatever. I just think this is almost like it's a random Tuesday in her life, and this is what we're doing Tuesday. We're going to go to trial. We're going to use it to like have these confrontations and all this kind of stuff and drama. Oh, excuse me. So, you know, it's like, what does she have to lose? Right. She doesn't care. Yeah, a definite waste of tax money. I mean, it's just like, I'm curious to see just how they piece the story together. I'm curious from from a legal perspective how they rope her in with the Brandon Boudreaux thing, the evidence that will come out there, and I'm also assuming that her niece would be on the stand for that. The other Melanie, not Melanie Gibb. And yeah, Marie says it's all about that attention. Yeah, she loves that attention. Loves that attention. Oh, she's going to think of the little attitude. But see, again, if she's smart, she will not get this little sassy tone with people like Kay. Here's the thing. You put Kay on the stand, who I think Kay can completely handle herself. You put Kay on the stand in front of in front of the jury, and you talk to her the way she's talking to that judge, how do you think that's going to go over? I mean, the jury's not going to want to hear her talk to the judge that way, but let alone a victim. You know what I mean? Because you already know the story that Kay is going to tell. It's going to be heartbreaking. And then if you got Lori up there with her little sass, it's not going to end well. Not going to end well. At all. Yeah, I could see her being like imagine she shows up with her rack belt and it's supposed to be hidden, but she's like done like a little tufted moment with her blouse and whatever she wears, it will be a blouse, right? And she kind of has it like, you know, a little tufted little number going on with the belt. Like she's treating it like a belt. Okay. She's treating it like a legit belt. Oh yeah, Melanie. But yeah, I can't wait to see Melanie, the niece testify. Cannot wait. Yeah, she's on a strict no honey bun diet. She's like, look, I've gone vegan, at least until trial's over. I'm trying to win my freedom to the portal again. Right, she might bedazzle the rack belt. Yeah, she just sounds so like immature, right? Like you just said, like an angsty teen, Heather. Yeah, it's really how she comes off. Her smarmy attitude is so frustrating. But again, we'll see what she does. I can't wait, y'all. When she gets up there and talks to the jury, hi, my name's Lori, but you already know that, don't you? You know what I mean? Like, it's going to be so cringy, I think. And especially if she's like, if like her presentations, it's like little stick figures. It's going to be cringy. It's going to be pure cringe. Okay. So here's what we'll do, because I'm tired. I need to go I've been up super early. So what we're going to end it all with, we got a little circus going on in here. So today is Tuesday. So tomorrow's Wednesday, right? We're going to see what happens tomorrow we either will go live tomorrow night or we'll do our regular Thursday, and we'll pick something. Maybe we'll do a poll. We could either do like Melanie Gibb or Julie Rowe, something, right? Like a little bit of a palate cleanser. So we'll see. So that's it. So anyways, thank you all the moderators for holding it down in here tonight. Thank you everybody for being nice and friendly and fun and all the things. And that's it. I hope y'all have a wonderful Wednesday halfway through the week. And yeah, unless something major's gone down yesterday, we'll plan on doing our regular live stream Thursday, but it won't be like necessarily a revisiting evil. It'll be more like one of the interviews from this, just to kind of continue prepping us for it. So that's it. Anyway, that's it. I love y'all. Y'all have a wonderful evening. Let's do our little dancey poodle, our little song that Slow Morrison did for us. Thank you, Mr. Slow. And that's it. Thank you again to all the moderators for hanging out and keeping the cushions fluffed and everything in order. I do appreciate y'all. And y'all have a good one. And I shall see you tomorrow or
The pillows are fluffed thanks to Miss Emily. The couch is wide enough. Join the family. It's all love while we laugh at first criminalities. Hey, 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 welcome to the Sofa Squad. Sipping from the cup at hey, 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 come laugh with the Sofa Squad. Can't roll my damn eyes hard enough. Oh, please, the puppies need me. Oh, oh, please, my body is rejecting none of that fancy credential stuff. I'm just here for the cringe binge. Hey, 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 welcome to the Sofa Squad. Sipping from the cup and hey, 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 come laugh with the Sofa Squad. Can't roll my damn eyes hard enough. Puppies need me, oh please. My body is rejecting none of that fancy credentialed stuff. I'm just here for the cringe binge. Hey, 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 welcome to the Sofa Squad. Sipping from the cup that hey, 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 come laugh with the Sofa Squad. Can't roll my damn eyes hard enough.